So I have an important update in the current assault weapon ban challenge that is up for Supreme Court review. 29 states have now joined to request that the Supreme Court finally address whether or not rifle bans are in fact constitutional. So let's talk about what is happening. Now, really quick before we jump into this video, I want to thank one of the new supporters of the channel, which is Brownells. Brownells is an amazing company. They support the two-way cause. I actually recently got to spend some time with them out in Iowa, got to see the facility, hang out with a lot of the people there, and they just believe in the Second Amendment. They are an amazing company. So if you guys want to support a company that supports you guys and get, great prices on products that you're looking for, check out Brownells. I can't link to them, but if you order using the code SCHOLAR10, you can get 10% off of your order. Now, as I mentioned in the intro, in this video, we're going to be talking about how this assault weapon ban case, which is currently seeking Supreme Court review, is getting support by 29 states. In this video, we're going to be discussing the Maryland assault weapon ban case, which was Bianchi versus Brown, which is now called Snope versus Brown. We recently received an amicus brief to the Supreme Court from 29 states, and those 29 states are requesting that the Supreme Court finally address whether or not state rifle bans are in fact constitutional. These 29 states argue that these rifle bans are not constitutional and that the Fourth Circuit's recent decision upholding this rifle ban was so clearly incorrect, or it was just outright defiance of what the Supreme Court recently ruled in Bruin and other cases. The Fourth Circuit en banc panel stuck to their position that semi-automatic rifles like the AR-15 are useful in military service, that they are militaristic weapons, and because of that, they are not arms protected by the Second Amendment, and they are so dangerous and unusual that they can be outright banned by a state. And now 29 states have joined together to support the plaintiffs here in asking for Supreme Court review and for the Supreme Court to finally once and for all address this issue of rifle bans. Now, for those of you who are curious, the 29 states are Idaho, Alabama, Alaska, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, Virginia, West Virginia, Wyoming, and Arizona and Wisconsin. This ban was challenged in a federal district court, and in the complaint, the plaintiffs here had to concede that their Second Amendment claim was originally blocked and foreclosed because the Fourth Circuit had already ruled on this issue before about the Maryland rifle ban in a prior case called Colby. The Colby case had already challenged the Maryland assault weapon ban, but the Fourth Circuit on the Colby case upheld the rifle ban as well. This case, Bianchi/Snope had to concede that the Colby case was controlling precedent, but they argued that it was so incorrect and should be reversed on appeal. The district court on review said that the Snope case was not valid because of the prior Colby decision, so they dismissed the lawsuit. That dismissal of the lawsuit then was appealed up to the Fourth Circuit. The Fourth Circuit once again upheld that dismissal, and then that meant that this case, Bianchi, made its way to the Supreme Court for the first time back in 2022. At that time, they were seeking review of those dismissals in 2022, but the Bianchi/Snope case was put on hold because the Supreme Court was set to rule in the Bruin case. Now, after issuing that ruling, the Supreme Court then GVR'd the Snope case, which means they granted, vacated, and remanded the judgment back down to the Fourth Circuit for a new review, new consideration in light of Bruin. Now, once this case got back in the hands of the Fourth Circuit, they held oral arguments in the case, but then the case sat silent and nothing happened for 13 months. Then suddenly we got news from the Fourth Circuit en banc panel that they were going to take the case out of the hands of the three-judge panel and review it on their own. And they did that because they did not want a pro-2A decision to be issued by the three-judge panel, so they took control of the case. And recently they did issue their decision upholding the Maryland rifle ban once again, finding again in their eyes that AR-15s and similar types of rifles are militaristic, that they are in military use, and therefore they could be banned by the state. The Fourth Circuit en banc panel stated in their decision that, with the respectful consideration and benefit of Bruin, we now uphold the judgment below. The assault weapons at issue fall outside the ambit of protection offered by the Second Amendment because, in essence, they are military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense. They also went on to argue that the Bruin analysis did not change anything in Colby or this Bianchi case at all, and therefore their decision was consistent with what the Supreme Court said in Bruin and all these other cases. Now, there were some dissents in that opinion. You had judges like Richardson, Niemeyer, Agee, Quattlebaum, and Rushing. All of them dissented, and in their dissent, they stated that after the Supreme Court decided Bruen, it remanded this case for us to determine whether Maryland's assault weapon ban violates the Second Amendment. Now the majority decides that Maryland's ban is perfectly consistent with the Second Amendment, but the majority's rationale disregards the Second Amendment and controlling precedent. Rather than considering the amendment's plain text, the majority sidesteps it altogether and concocts a threshold inquiry divorced from the right's historic scope. To make matters worse, it then misconstrues the nature of the banned weapons to demean their lawful functions and exaggerates their unlawful uses. Now, after that terrible Fourth Circuit decision, there was a clear path to go to the Supreme Court on a final merits, which is what the Supreme Court had said for a while that they wanted. So the plaintiffs have now submitted to the Supreme Court review of this case, and they're asking for the Supreme Court to once and for all address this issue. And like I mentioned, now you have 29 states that have joined together in an amicus brief to ask for the Supreme Court to in fact grant that review. Now, in their amicus brief, they state that this court should reject this latest attempt to give a critical constitutional right second-class status. Without correction, the Fourth Circuit's decision will muddy the clear Second Amendment standards that this court has adopted, and its decision will encourage other governments to erode Americans' essential right to keep and bear arms. They went on to state that Maryland has no prerogative to limit available firearms to whatever it deems necessary for self-defense. That is not how the Second Amendment works. The amendment, rather, stands as a reminder to governments, state and federal alike, that the people have a pre-existing right to keep and bear arms. The right guarantees the people the very arms Maryland has banned. They go on to state that Maryland's job is to recognize and respect that right, not empty it. And then they say that confronted with Maryland's sweeping firearms ban, the Fourth Circuit should have made short work of it. But then they say remarkably, however, the Fourth Circuit held that the firearms that the Firearms Safety Act bans are not actually arms at all. They state that in defiance of the Second Amendment's plain text and this court's precedents, the Fourth Circuit carved out the military-style weapons from the ordinary definition of arms. It adopted a view that requires citizens, not the government, to show that widely used weapons are appropriate for them to use for self-defense based on whether the weapons have a low enough level of firepower and accuracy. And then they say that the burden was shifted from what it should have been, where Maryland would need to put forward history and tradition to support this ban, to all of a sudden now the plaintiffs have to show whether or not they actually need to use these for self-defense, or if there's a good enough justification that these weapons can be used in self-defense. And here these 29 states are saying that is not the Bruen analysis. The Fourth Circuit knows that, but they are engaging in something that is clearly incorrect because they just want to ban these items. So in this brief, you have 29 states joining together to point out how completely unconstitutional this Maryland rifle ban is, and also that the Fourth Circuit got the analysis either completely wrong because they have no idea how to faithfully apply Bruen, or they just engaged in outright defiance, like some of their dissenters in the Fourth Circuit said. That the court here at large, the Fourth Circuit en banc panel at large, just simply does not like Bruen, so they are bending the test to reach whatever goal they want, which is a complete ban on these types of rifles. So ultimately, great news that you have 29 states joining together to petition for the Supreme Court to in fact grant review to this case. This is a critical case. It's a final merits case the Supreme Court has wanted for a long time. It's an issue that we've all wanted for a long time, and it would not just impact states like Maryland, but other states like California, New York, New Jersey, and others who also have these type of state rifle bans. Now, also have no doubt that those states like California, New York, New Jersey, Illinois, and others who also have rifle bans will soon join together, maybe file an amicus brief asking for the Supreme Court to deny review because they don't want the rifle bans to be overturned. So again, important news, great news that 29 states are joining together to petition for the Supreme Court review. This is a critical case we are going to be watching closely going into the Supreme Court's next term. And if anything else develops, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.